Thank you for reviewing the Americans with Disability Act training. My name is Jennifer Bumgarner and I am the Executive Director of Academic Support at Craven. One of my duties is to act as the ADA coordinator on campus. I want to take this opportunity to shed light on this topic that is sometimes confusing for students and faculty. ADA accommodations are most often written for the classroom, but it is everyone's job on campus to be mindful of individuals with disabilities. A garbage can blocking access to paper towels, a table placed in front of the automatic door button, staff plowing snow into the disabled parking spaces or access lanes, an instructor banning laptops in the classroom except for those with accommodations. Why should an instructor never do that? We should never do anything that singles individuals out, especially anyone with a disability. My role as the ADA coordinator is to understand disability laws and what the school's obligations are in relation to these laws. It is also my responsibility to maintain a knowledge of common accommodations. It is also my job to work on behalf of the school and the student to find the best accommodation for our students and ensure the college is in compliance with those accommodations. I also work with students and faculty to problem solve uncommon accommodations requests as well. The goals of this training are to improve your knowledge of the laws, regulations, and guidelines related to the Americans with Disabilities Act and other related laws, to discuss the rights and responsibilities of the college, staff, faculty, and students. We will explore common issues related to ADA. A review of the current ADA process at Craven Community College will be covered. We will also cover the faculty's role regarding the implementation of awarded accommodations, the laws that apply to institutions of higher education, and the implications of those laws. There are several laws that govern ADA regulations. I am going to cover the laws specific to post-secondary institutions and student accommodations. Section 504 of the Rehabilitation Act of 1973, the Americans with Disabilities Act of 1990, North Carolina Senate Bill 866 passed in 2002, the ADA Amendment Act of 2008, and the Higher Education Opportunities Act will be summarized. Last but not least, the Dear Colleague letter written June 29, 2010 will be addressed as well. Section 504 of the Rehabilitation Act of 1973 states that colleges may not discriminate in the recruitment, educational process, or treatment of students. Section 504 also states that students who have self-identified, provided documentation of disability, and request reasonable accommodations are entitled to receive approved accommodations, modifications of programs, appropriate academic adjustments, or auxiliary aids that enable them to participate in and benefit from all educational programs and activities. This law is the reason we have to be flexible in providing accommodations and ensure that individuals have access to everything the college provides, on and off campus, inside and outside the classroom. The Americans with Disabilities Act was passed in 1990 and then amended in 2008 to provide a clearer definition of disability. The ADA of 1990 provides civil rights protections to individuals with disabilities and also prohibits discrimination against individuals with disabilities. Between the passing of the ADA law in 1990 and up to 2008, several issues arose concerning what is actually meant by disability and what makes a person disabled. The ADA Amendments Act in 2008 clearly defined a disability as a mental or physical impairment that substantially limits one or more life activities. Those life activities are listed as walking, seeing, hearing, speaking, breathing, learning, working, caring for oneself, or performing manual tasks. Anyone who can provide documentation of any impairment that affects any one of these activities will be eligible for reasonable accommodations once documentation is provided. Other laws that have implications in higher education are the North Carolina Senate Bill 866, passed in 2002, and the Dear Colleague letter written in 2010. Both of these documents address electronic information being accessible to individuals with disabilities. These two documents have been the catalyst for the new requirements centered on making digital material accessible. The Higher Education Opportunities Act, passed in 2010, allowed students with intellectual disabilities to be eligible for federal financial aid. It is important to know the laws that govern ADA compliance, but even more important to know the rights and responsibilities of the college, faculty, students, and staff under these laws. The college has certain rights and responsibilities under the laws. The college has the right to request documentation that supports accommodation requests. The college can deny a request for an accommodation if documentation does not show the need. The college can compromise and select among equally effective accommodations. For example, an instructor can provide copies of their notes instead of a note taker, or provide a note taker instead of the instructor notes. The college has the right to refuse accommodations that impose a fundamental alteration to a program or activity. For example, a student can request additional days to complete assignments, but student forums rely on students answering and responding in a timely manner. Thus, the extension on due dates may exclude student forums. The college has the responsibility to accommodate known limitations and ensure everything is accessible. The college has the responsibility to maintain confidentiality of all ADA recipients. And most importantly, we have the responsibility to provide accommodations without compromising content, quality, or level of instruction. This is the reason it is extremely important to have open lines of communication between faculty and ADA coordinator. Students are afforded several rights and responsibilities under the law as well. Students have the right to have equal access to everything the college offers. Students have the right to equal opportunity to learn, work, and receive accommodations. Students have a right to have their information be held confidential and to receive information in accessible formats. The responsibilities of the students are to meet qualifications and maintain institutional standards in all areas of the college. Students have the responsibility to self-identify their disability, request accommodations, and provide the required documentation. Students also have the responsibility to follow all published procedures for obtaining academic adjustments. Just like the college and students, faculty have rights and responsibilities as well. Faculty rights and responsibilities are separate from the college because under ADA law, an individual can be held liable if found non-compliant with ADA laws. Faculty have the right to request a written agreement before allowing a tape recorder in class. Faculty have the right to expect and enforce the behavior conduct policy of the college. No disability trumps this policy. Faculty have the right to challenge an accommodation, but faculty cannot challenge the student. The communication must happen with the ADA coordinator. An instructor cannot make a decision to stop providing or make changes to an accommodation. Faculty have a responsibility to provide reasonable accommodations for students when you receive an accommodation form. Instructors have a responsibility to not provide accommodations without a written accommodation form from the ADA coordinator unless you are willing to provide the accommodation to the entire class. Faculty have the responsibility to not single out or identify students with accommodations in any way. Faculty have academic freedom, but that does not supersede any accommodation from the ADA coordinator. The instructor may have some leeway in the way the accommodation requirement is met, but anything unusual or out of the norm should be discussed with the ADA coordinator. You should always contact the ADA coordinator when the student is uncomfortable or unhappy with an accommodation. Academic freedom is not a legal mandate, unlike the ADA laws. There is nothing common or good about an ADA issue. Complications related to ADA issues can result in legal actions against the college and/or individuals. These are examples of legal battles that resulted from common ADA issues. The Office of Civil Rights will respond to any complaint filed. In these 3 cases, the community colleges were found to be non-compliant with ADA laws. The results were loss of money for the college in the form of tuition refunds and a lot of time and energy invested in ADA training. The OCR will often monitor a college for an extended time period when they are found to be non-compliant. The most common complaint received in the Office of Civil Rights is instructors not providing awarded accommodations to students at all or in full. It is crucial that we are diligent about providing the accommodations as written. These are a few common issues I have experienced in the past at Craven Community College. I have had instances where an instructor did not provide the accommodations at all. I have had other instructors try shortcuts around accommodations and others try to make the accommodations seem optional for the instructor. There is no way around any accommodation. Compromises are always possible but need to be facilitated by the ADA coordinator. The ADA coordinator is there to ensure the process is compliant with ADA law. Ignoring an accommodation is never an option. Let's talk about the accommodation process and the best ways to administer the accommodations. The process to receive accommodations at Craven Community College is as follows. A student must complete the Student Request for Disability Accommodations form found on the Accessibility Service page at Craven's website. This is the first step. Once the form is completed and brought to the ADA coordinator, a discussion is then had with the student about the required medical documentation that must be provided in order for accommodations to be awarded. Once the medical documentation is received, a student interview is conducted after the documentation is reviewed. Accommodations are then awarded, and the student accommodation form is completed and signed by the student and the ADA coordinator. It is then the student's responsibility to deliver the accommodation form to the instructor for his or her signature, and then return the accommodation form to the ADA coordinator, where it is then filed in the student's folder. Once the form is received and signed, accommodations should be provided immediately. If a student is in an online course, then the accommodation form will be completed and signed by the coordinator and student. The ADA coordinator will then scan the form and email it to the instructor. A response to that email is used in lieu of the instructor's signature. This is a copy of the current ADA form being used. It is signed by the student, ADA coordinator, and the instructor. The faculty's role in the accommodation process is to contact the ADA coordinator immediately if you feel that changes should be made to the accommodations. It is impossible to know the setup and delivery of every classroom. The ADA coordinator relies on feedback from instructors if an accommodation may not work in your class as written. Faculty need to implement the accommodations as written and not make changes to the accommodations. It is important that faculty make students aware of ADA services and refer students to the ADA coordinator when needed. As an institution and individuals, we can be held liable for not telling a student about disability services when it is warranted. Oftentimes, instructors will see common accommodations repeated among different students. Testing accommodations are among the most common. Although testing accommodations are regularly sought, the details of that accommodation can vary. Some students may receive additional time for test. That additional time is often plus 150%. But if a disability warrants it and the student requests it, extended time could be plus 200% or altogether unlimited. The awarded amount of time is based on the documentation provided and a determination made by the ADA coordinator. If an instructor feels that an extended time will compromise the test in some way, they need to discuss the concerns with the coordinator. Accommodations for extended time are also accompanied by testing in a distraction-reduced room. This is to allow for the extended time. All tests with accommodations should be taken in the Academic Skills Center. Less common testing accommodations might include chunking larger tests into smaller units and tests more frequently. Testing accommodations apply to all types of tests, including quizzes. Another common accommodation is the use of a note taker in class. When this accommodation is awarded, the note taker verification form will accompany the student's ADA accommodation form. During the first class meeting, or as soon as you receive the accommodation form, please ask the class for a volunteer note taker. Do not identify the reason for the need or who the notes will be taken for at that time. An incentive for the volunteer is a $100 bookstore scholarship. Once you have a volunteer, introduce the student who will receive the notes and help them devise a plan for obtaining copies. Complete the note-taker form and have the note-taker or student return the form to the ADA coordinator. This is the only way the scholarship will be awarded. If something happens that the note-taker does not fulfill the duties, the instructor should let the ADA coordinator know and the scholarship will be removed. An accommodation for a reader is a testing accommodation. It is often awarded to students who have a learning disability in reading or may be sight impaired. Students with a learning disability in reading often find it difficult to process what they have read. However, if things are read to the student, then the information can be properly processed. Often these students show marked improvement in test scores when they have a reader. If a reader is assigned an accommodation, then the test must be sent to the Academic Skills Center and scheduled. Be aware that it could take more than one day to schedule the test. The testing coordinator can also schedule your test in advance if you know when the test will be administered. An accommodation for a scribe is much like the reader accommodation. It is a testing accommodation and must be scheduled in the Academic Skills Center. Excessive absences and tardies is an accommodation that is not awarded unless proper documentation supports it. When this accommodation is awarded, students are made aware that they are responsible for making up any work they miss. They earn the grade they earn. No special consideration is given when assigning grades. Alternate due dates need to be given when a student is making up work. Students assigned this accommodation are made exempt from the attendance policy, which means they should not be dropped or withdrawn from the class by the instructor due to absences. The student is responsible for withdrawing if that needs to happen. Likely a medical withdrawal is best. If the student does not withdraw from the class and does not do the work required to master the content, then the student should earn an F or whatever grade the instructor feels is appropriate. Generally, if a student has missed more than 25% of the class, we should discuss withdrawing the student, but the academic coordinator should be contacted first. If an accommodation is written for excessive absences or tardies, then an instructor cannot require a doctor's note for any of the student's absences. A doctor or medical professional has already provided the needed information to the ADA coordinator. Accommodations given at the college level are different from accommodations given in K-12. IEPs and 504 plans are awarded in the K-12 system and guarantee success. Accommodations awarded at the post-secondary level only guarantee access, not success. It is our responsibility to put the student on a level playing field with other students who do not have a disability. The burden of proving the disability is also placed on the student at the college level. Accommodations must always be reasonable. In reality, most requests for accommodations are going to be reasonable, and the college is required to provide the accommodation unless it falls into one of the unreasonable categories. An accommodation will not be provided if there is a direct threat to the health and safety of others. An accommodation that will cause a substantial change in an essential element of the curriculum cannot be awarded. If an accommodation request were to create a substantial alteration or change in which services in a class are provided, the accommodation would not be approved. Lastly, if an accommodation were to place an undue financial or administrative burden on the college, we might decline the accommodation. However, the Office of Civil Rights advises that this will rarely be an acceptable reason to deny an accommodation request. OCR will examine the college's entire budget to determine what hardship it might create. Single department or unit budgets are not taken into consideration. Here is a list of common, reasonable accommodations often awarded. This is not an exhaustive list, and accommodations can be as unique as the person and the disability. These are a few simple do's and don'ts when encountering anyone with accommodations. Do talk to the student about the accommodation and work out any logistics of providing the accommodation. Always treat disabled students the same as non-disabled students. Be respectful and mindful about where you discuss ADA-related requirements with students. And remember to refer students to ADA services when needed. Please do not make assumptions about a student's ability. Do not even engage in a philosophical debate about fairness to other students. Please always allow students to use a tape recorder in the classroom when they have this accommodation. Please do not ask to review the disability documentation for any student. Documentation is confidential and the ADA coordinator will not break confidentiality to discuss the nature of anyone's disability. Last but not least, what do we do with those animals that students bring to class with them? Only 2 animals are recognized as a service animal: dogs and a miniature horse. These animals are not required to wear a service animal vest, and there is no certification training officially recognized that will prove the dog or miniature horse are legitimate service animals. When these animals are encountered on campus, you can ask 2 questions only. Is that a service animal? What task does it perform? How a student answers those questions will determine the course of actions that need to be taken. If you encounter this situation on campus, ask the student, is that a service animal? If the answer is no, then the dog cannot be on campus. If the answer is yes, then the next question to ask is, what task does the dog perform? If the student's answer is something like, it helps me with mobility issues or warns me of the onset of a seizure, then the student does not need an accommodation form from the ADA coordinator. If the answer to that question is, the animal is an emotional support animal or it keeps me calm, then the student is required to go through the accommodation process with the ADA coordinator and obtain an accommodation form. Individuals should always clean up after their service animal and keep the animal under control at all times. Students also need to ensure that there is no disruption in the classroom due to the presence of the animal. Please remember, if in doubt, pick up the phone or email the ADA coordinator.